Yeah, I'm ready.
Members of the jury, it now becomes the duty of the court to give you your instructions upon the law which must guide you in your deliberations in this case, wherein the people prosecute by indictment one William Armstrong for the crime of assault in the first degree and the crime of assault in the second degree. At the outset, I desire to express to you my thanks for the manner in which you have, during the past 6 or 7 years, given your complete attention to your duties at this trial. At considerable inconvenience, you have set aside your personal affairs, and you have devoted your entire time to the issue here for the purpose of performing a solemn and very important duty in the relations of civilized society, that is, jury duty. The defendant at the bar is charged with a serious crime. I mention that at the outset so that you will come at once to a full appreciation of your responsibility and your duty as a juror, and to the great importance of the task that is before you. It is important to the defendant because to him it involves his liberty. If he is not guilty of this crime, he should be acquitted and discharged from custody. It is important for the people, for if the defendant is guilty of the crime charged against him, the peace and the order of the community and the vindication of the law require that he be convicted and punished. This case has been very ably tried by learned and experienced counsel on both sides. The skill, the ability, the zeal, and the devotion to duty of counsel in behalf of the defense, and the learned assistant district attorney who represents the people, is deserving of the highest commendation. In the course of a protracted trial, occasions are bound to arise when differences of opinion among counsel will cause acrimonious discussion. You must disregard, gentlemen, what the court may have said to counsel on either side during the course of this trial in the maintenance of the dignity which the court always seeks to enforce in the conduct and administration of justice. Counsel have been courteous and tactful, representing their respective sides fairly, honestly, and in a proper manner. Under our system of jurisprudence, the functions of the court and of the jury are separate and distinct. It is the duty of the court to declare to the jury the rules of law that are applicable to the facts in the case. It is the duty of the jury to accept and to apply them in determining the questions of fact involved. The court is likewise required to pass upon all questions that arise during the trial as to the admissibility and competency of evidence that is offered, to the end that no improper or illegal evidence may be permitted to creep into the case. For all rulings of law, the court assumes full responsibility. With that, you have no concern. You, as jurors, are the sole and exclusive judges of all questions of fact. You, too, are the sole and exclusive judges of the credibility of all witnesses and of the weight that should attach to the testimony given by any particular witness. Likewise, are you the sole and exclusive judges as to what inferences may arise or may properly be drawn from a set of facts that may have been proven in this case. If counsel on either side had asked you to draw inferences that may be drawn from the facts in the case or from the credible evidence in the case, it is your duty to accept such inferences as they state them to you. If, on the other hand, they ask you to draw inferences which are not based on the facts, then you should reject such inferences. The defendant on trial is brought into court by what is termed an indictment. An indictment is a written accusation which the grand jury of the county makes against a defendant, charging him with the commission of a particular crime. The indictment in and of itself is no evidence of guilt. The grand jury hears only one side of the case, namely the people's side, and before that body no opportunity is offered the defendant to be represented by counsel or to cross-examine witnesses. Innocent men sometimes are accused of crime. The mere fact that the defendant is charged with a crime should be taken by you as no evidence whatever of his guilt. Under our system of law, the defendant, as with all defendants in criminal cases, is presumed to be innocent. That presumption of innocence is his property and remains with him throughout the trial and at all stages of the case, up to such time, if such time should arrive, as the jury becomes satisfied of the defendant's guilt beyond a reasonable doubt. This presumption of innocence is a bulwark for the protection of the innocent, but it is not a shield for the escape of the guilty. If the evidence measures up to a point where the defendant's guilt is established beyond a reasonable doubt, then the presumption of innocence is destroyed and the defendant should be found guilty. A reasonable doubt is not a whim, a guess, or a surmise, nor is it a subterfuge to which resort may be had to avoid the performance of what may be a disagreeable duty.